Fellow South Africans, I just only want to take you quickly through my submission to Parliament, and then it goes as follows. In the legislature, good people, it means a synonym. It is government, parliament, administration, senate or assembly, which is the National Assembly. So it is the same thing. Parliament is in Cape Town. That is my ID number, and then that is the first number that they must deal with. And then in the matter between the 6th President of the Republic of South Africa, Lieutenant Commander Sylvester Volane Mangolele, and the state, first defendant, the 5th President is the second defendant, the Speaker of Parliament is the third defendant, the quorum to Constitutional Court case number 12 of 2020 is the fourth defendant. Be pleased to take notice that the 6th President, Lieutenant Commander Sylvester Volane Madala Mangolele, herein after referred to as the plaintiff, act in terms of Section 84(2)(d) of the Constitution of the Republic of South Africa, Act 108 of 1996, herein after referred to as the Constitution. And when we go to this particular issue, the Constitution, Section 180, 84(2)(d) of the Constitution of the Republic of South Africa, to summon the National Assembly of the National Council of Provinces of Parliament to an extraordinary sitting on 16 September at 10:00 to conduct special business as provided for in terms of Section 180C of the Constitution concerning the administration of justice that is not dealt with in the Constitution, including the participation of people other than judicial officers in court decision for an order in the following terms. Enrolling this matter in terms of Rule 130 of the National Assembly Rules. A second defendant to, in terms of Section 84(2)(j) of the Constitution, pardon or reprieve the plaintiff and remitting any fines, penalties or forfeitures. And the second defendant must, in terms of Section 84(k) of the Constitution, confer honors to the plaintiff. Compel the first defendant to fulfill the obligation imposed by the Constitution to respect, protect, promote, and fulfill the plaintiff's right enshrined in the Bill of Rights. Remove the second defendant on the grounds of a serious violation of the Constitution or the law, a serious misconduct, inability to perform the functions of office, and remove the third defendant from office by resolution. Call for the removal of the fourth defendant by resolution. Defendants be ordered to pay cost. All defendants are called to admit or deny each term submitted in support of this notice of motion before the National Assembly, dated at Cape Town on this 13th day of September 2021 by the plaintiff. To Parliament of the Republic of South Africa, I'm serving by email to Info Parliament. Security of the Republic of South Africa. The plaintiff is security of the Republic, obligated in terms of Section 1995 of the Constitution, and to give effect to the principles of transparency and accountability. Multi-party parliamentary committees must have oversight of all security services in the manner determined by national legislation or the rules and orders of Parliament as provided for in Section 1998 therein, And in any event, in exercising any power or performing any duty in the defense of the Republic and matters connected therewith, the plaintiff have regard of the principles that the formulation and execution of defense policy is subject to the authority of Parliament and the national executive. National security must be pursued in compliance with the law, including international law, and is subject to the authority of Parliament and the national executive, in which the resolve to live in peace and harmony precludes any South African citizen from participating in armed conflict, nationally or internationally, except as provided for in terms of the Constitution or national legislation. And the plaintiff reflect the resolve of South Africans as individuals and as a nation to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life from corrupt administration as an imposed obligation in terms of Section 198 of the Constitution. The defendants are a decline in critical capabilities which are arrested through immediate directed interventions as obligated in terms of milestone 1 of the South African Defence Review 2014, having regard of an imposed principles at Section 2A of the Defence Act 42 of 2002, hereafter referred to as the Defence Act. C. The application to Constitutional Court case number CCT 12 of 2020 and how it is unlawfully and intentionally misrepresented by the fourth defendants. And other defendants agree with the fraud committed. Fraud means unlawful and intentional making of a misrepresentation that causes actual or potential prejudice to another, such as the plaintiff in this matter. And to quickly take you through to these particular requirements. This is the case, is the application, and in this particular application, let's look for the court order quickly. Order. Jesus Christ. Where is this order? Okay, wait. Order. There we go. Thank you. So when you see this particular application, this is the scanned copy that was sent to me from the Constitutional Court, and then it has all the original stamps received by the parties and so forth. It is an application with Lieutenant Commander Sylvester Mangolele as the plaintiff and the State of the Republic of South Africa as the first defendant, the President as the second defendant, and all other defendants to the 15th defendant. The court order is Sylvester Volane Mangolele. It now assumes that I'm not a lieutenant commander. Secondly, the first respondent is the President, not the state. It's a misrepresentation. Thirdly, the Chief Justice of South Africa is the fourth respondent in this matter. Here, the Chief Justice is respected as the Chief Justice, as the fifth defendant on the matter. Now, the other thing is here, you now subsequently have 14 respondents instead of 15 defendants. The quorum, which are the quorum to constitutional case number, are these people. The uniqueness of these people is that all these other justices, they have admitted that the Chief Justice of the Republic of South Africa is a respondent on the matter. However, they allowed the Chief Justice to judge himself. And the other thing is that the manner at which the Constitutional Court arrives at a decision it is as contemplated in terms of section of the Superior Courts Act. In terms of section 12, if I'm not mistaken. My library still serves me well. I am tired. I am stressed. I am a human being. I do have feelings. In chapter 4, let's go see. No, these are the Supreme Courts Act. Supreme Courts Act and the Superior Courts Act are two different pieces of legislation. That is why I emphasized on my Superior Courts Act. There it goes. You know, I know these things because I read them. I refer to them when I write all these documents, and these are what the President must do in any event, because this is the law of the Republic. I think it is section 12, the manner at which this courts, chapter 4, section 12.3, the one that has been grossly violated in this regard. And I show you this so that there is no argument of the proof of any terms advanced in this particular video. The manner of arriving at a decision by a constitutional court. No judge may sit at the hearing of an appeal against a judgment or order given in a case in which was heard before him or her. So I must understand that any other person designated can act as the Chief Justice depending on their respective seniority. It's like, for an example, it will be currently now, as you have seen in the matter that was published recently relating to the elections, it was acting Chief Justice Zondo, and it can subsequently be the President of the Supreme Court of Appeal, Justice Maya, called to act as the Chief Justice in a matter where the Chief Justice is called to respond or defend. But the bottom line is that the Constitutional Court is one court, and the Constitutional Court must function serving all people as equal before the law. So you need to understand that the incumbent Mogoeng as a Chief Justice is a person equal before the law, who is responsible as it is said in this particular matter. The Defense Act in Section 104(10) imposes an obligation to be upheld by the legislature that any person who obstructs or interferes with the defense force in the execution of his duties in terms of this act or the Constitution is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 25 years. And it is correctly so, as obligated in terms of the Defense Act when one looks at Section 104(10), which is the recent section that I've been looking at in drafting this particular document. Section 104(10) imposes an obligation that any person who obstructs or interferes with the defense force in the execution of its duties in terms of this act or the Constitution is guilty of an offense and liable on conviction to a fine or imprisonment to a period not exceeding 25 years. The plaintiff is an apolitical commissioned officer and cannot toy or campaign to uphold, defend, and respect the Constitution. Respect the Constitution as the supreme law of the Republic, as the sixth head of state, head of the national executive, and commander-in-chief of the defense force, who must promote the unity of the nation and that which will advance the Republic, as obligated in terms of Section 1995, Section 83, read with Section 2021 of the Constitution. And this is cemented by a legislative provision in terms of Section 104(13) of the Defense Act, which provides that any person who recruits or attempts to recruit any member of the regular force for membership of any trade union other than a military trade union which is duly authorized to act as such, or incites or attempts to incite a member of the defense force to participate in strikes, demonstrations, or protest prohibited in terms of the regulations, is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. Excuse me. And I think this must come down. It will be unfair to the six to be left alone as such. Any member of the defense force or of any auxiliary service who participates in any strike or secondary strike action is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. See Section 104(14) of the Defense Act. 104(14) of the Defense Act, it tells you exactly what I have just alluded to you thus far. And I need to go back to something here and fix it. As contemplated in terms of section. Section. What section is that? 2A of the Defense Act 42 of 2002. Here in referred there. Oh, referred to as the Defense Act, and then I must correct this other one where I think I have extended this part. Come out. Good. What? Close. Control B. Close. It's called due diligence, good people, when you do things and then you follow as you were taught at Naval Staff College or during training in terms of Section 54 of the Defense Act. Remember, excuse me, I am drafting this particular matter and then I am proofreading it to you such that you understand exactly what is happening in this particular matter. And I was in Section 104.14. And we proceed further to submit that a person is guilty of an offense if he or she in respect of public property or state money under the control of the department without good cause abandons, damages or destroys any such property or intentionally or through gross negligence fails to take effective steps to prevent unauthorized, irregular, fruitless or wasteful expenditure as contemplated in the Public Finance Management Act 1 of 1996 is liable upon conviction to a fine or imprisonment for a period not exceeding 10 years. See Section 104.20A of the Defense Act. Any person who undermines or stifles or seeks to undermine or stifle any procedure for the redress of grievance is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. See Section 104.17 of the Defense Act. And it states exactly as such. Any person who is liable to render service in the defense force by virtue of a military service contract with the defense force and refuses to render such service is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 1 year. See Section 104.12 of the Defense Act. Any person who is subject to this act who deserts or who deserts from the defense force is guilty of an offense and liable on conviction if he or she committed the offense while on service, to imprisonment for a period not exceeding 20 years, and in any other case, to imprisonment for a period not exceeding 10 years, as contemplated in Section 13 of Schedule 1, disciplinary and other military offenses. Lieutenant Commander Mangolele did not desert his duties in any event. Must fix this. Okay. You know, when you are free in the universe, our home, you are able to think and you are able to do things that other people cannot do and marginalize. Now, why? You don't want they want them whole. I see. Perfect. We'll undoubtedly have to zoom in a little, but do the things. So it's called editing due diligence, good people, before you release any document. And the role of the parties. Take notice that the above-mentioned plaintiff has commenced proceedings against the above-named defendants for the relief set forth in the notice of motion to be heard on Tuesday, 16 September. Nope. It cannot be Tuesday, 16 September. Thursday. You want this if people respect the ID number and the force number and respect their way of operating in service and defense, then this will happen in accordance with these terms. And in an event such terms are disputed, such must be explicitly set forth in response to paragraph by paragraph of this matter. Okay. Thursday on 16 September 2021 at 10:00 or as soon thereafter as the parties may be heard, a copy of which is herewith served upon you. The plaintiff, President Lieutenant Commander Sylvester Volane Madala Mangolele, defend and protect the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy. Defense Force Service regulations issued in terms of Section 62L of the Defense Act C. And then let's stop this. We have already introduced the Defense Act. The same applies with this Constitution. And why would we Okay. It serves that purpose. All these mistakes, you can't make a mistake, good people, because now it makes something to be misunderstood, and then it cannot be corroborated or aligned to any section. When you act in accordance with the Constitution and the law, everything that you say must be confined or prescribed to a section, and then save that particular regard. The state must respect, protect, promote, and fulfill the plaintiff's rights in the Bill of Rights. See section, and okay, that's section 7(2) of the Constitution. In addition, the first defendant has a duty imposed in terms of section 9(1) of the Prevention of Combating and Torture of Persons Act to promote awareness of the prohibition against torture aimed at prevention and combating of torture. The second defendant, the fifth president, is head of the state and head of the national executive and commander-in-chief of the defense force, who must uphold, defend, and respect the Constitution as the supreme law of the Republic, and promote the unity of the nation and that which will advance the Republic. Section 83 read with Section 2021 of the Constitution. Good people, this is what the President must do. It is the law. I'm calling the incumbent President Cyril Ramaphosa to come and do as he is mandated by the law. There. He is most the President right now. And when the law imposes obligations such as these, or the ones that you have already had, it is what the incumbent President Cyril Ramaphosa must uphold, must defend, and respect the Constitution as the supreme law of the Republic. That's all that the role of the President is here. If the Constitution says fathers must be with their children, that is what must happen. If the Constitution says criminals must be locked up, that is what must happen. If the Constitution says we must fight against criminal activity, corruption, apartheid, and misconducts or unjust acts committed by others to others, it is what we must do. The third defendant has sworn or affirmed faithfulness to the Republic of South Africa and will obey, respect, and uphold the Constitution and all other law of the Republic, and solemnly promised to perform her functions as a member of the National Assembly to the best of her ability. Section 48 of the Constitution obligates this particular provision. The fourth defendant, Chief Justice, is the head of the judiciary and exercises a responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. Section 1656 of the Constitution imposes this obligation. These are the roles of the parties. Main facts to consider. Be pleased to consider that in no event did the defendants have regard of the health or well-being of the plaintiff's family, especially that of the 83-years-old Leta Kukunana Machila as an elder who suffers irreparable harm, while it is regulated that it is an unavoidable reality that when a soldier is recruited, her or his family becomes a part of the Defense Force family as an institution to share in the joys, anxieties, and sometimes unfortunate outcomes of service, including maiming and death. Let me quote it. Subquote, quote, citing. It is regulated indeed as such. Be pleased to consider that in no event was the plaintiff's divorce order rescinded to limit his parental responsibilities and rights to Nyiko Mangolele in terms of Section 18 of the Children's Act. Be pleased to consider that in no event did the defendants respect, protect, promote, and fulfill the rights enshrined in the Bill of Rights in relation to the plaintiff and her minor child Aluta Songelwa, while all organs of the first defendant, which is the state, in any sphere of government, and all officials, employees, and representatives of an organ of the first defendant, which is the state, must respect and promote the rights of children contained in the Children's Act as obligated in terms of Section 8.2 therein. When you look at Section 8.2 of the Children's Act, it tells you that all organs of state there, in any sphere of government, and all officials, employees, and representatives of an organ of state must respect, protect, and promote the rights of children contained in this act. That is why children's best interests are of paramount importance in every matter concerning them. Be pleased to consider that in no event did the second defendant cancel the plaintiff's permanent commission in terms of Section 54(3)(a) of the Defense Act. We have spoken about the Act. Be pleased to consider that in no event was the plaintiff convicted to imprisonment for 5 years in terms of Section 105 of the Defense Act as unlawfully and intentionally misrepresented in the DoD personal system to be lawfully to be the lawful grounds of the alleged administrative discharge since 8 August 2018. Be pleased to consider that in no event was a sentence involving discharge or dismissal imposed upon the plaintiff under the code as obligated in terms of Section 59(1)(d) of the Defense Act. Be pleased to consider that in no event was the plaintiff heard or granted an opportunity of being heard on 14 September 2018 in the High Court of South Africa, Western Cape Division, Cape Town, as obligated in terms of Section 21(b) of the Vexatious Proceedings Act 3 of 1956. And that is the truth, or main elements, main facts to consider. Excuse me. Regulation to be employed or followed. Since section 12(1)d, let me bold this. Since section 12(1)d of the Constitution of the Republic of South Africa 1996 provides that everyone has the right to freedom and security of the person, which includes the right not to be tortured in any way. And mindful that the Republic of South Africa has a shameful history of gross human rights abuse, including the torture of many of its citizens and inhabitants, has since 1994 became an integral and accepted member of the community of nations, is committed to the preventing and combating of torture of persons, among others, by bringing persons who carry out acts of torture to justice as required by international law, is committed to carrying out its obligations in terms of the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment. And since each state party to the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment must take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction, the Minister of Defense and Military Veterans has, under Section 62L of the Defense Act 2002, made the regulation in the schedule. Whereas the Defense Force is a national asset which is mandated under the Constitution to be structured and managed as a disciplined military force, and in accordance with the principles of international law governing the use of force. And whereas the Defense Force is essential in the defense of the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy. And whereas the Defense Force provides a soldiering career wherein members entrust their inalienable right to life, which is guaranteed in the Bill of Rights of the Constitution, to the nation and the state. And whereas it is an unavoidable reality that when a soldier is recruited, he and his family becomes a part of the larger family of the Defense Force family as an institution to share in the joys, anxieties, and the sometimes unfortunate outcomes of service, including maiming and death. And whereas it is essential for an effective mechanism to be created to provide for the necessary duty of care to the soldier and his or her family. And whereas it is therefore necessary to create a working environment for the soldiering professionals that is positively conducive to discipline. And whereas these factors define the uniqueness of soldiering profession, this is what is expected of each and every soldier. When a soldier is told that a person X is committing crime and here is the proof of it, such soldier like General Rodzane Mapwanya is obligated to act in accordance with these terms and then create a working environment for the soldiering professionals that is positively conducive to discipline. In line with the uniqueness of the soldiering profession, kindly consider the attached here to SVMM1 President Lieutenant Commander Sylvester Volane Madala Mangolele as a statutory body in terms of the Constitution or the law, pending the dissolution of the 6th Parliament before expiry of its term, as obligated in terms of Section 50 of the Constitution. Dated the 13th of today. Crimes or offences committed. The defendants are guilty of high treason as persons owing allegiance to the Republic of South Africa and have unlawfully engaged in conduct within or outside the Republic with the intention of overthrowing the government of the Republic, coercing the government by violence into any action or inaction, violating, threatening, or endangering the existence, independence, or security of the Republic, changing the constitutional structure of the Republic. And to simply put you in that of changing the constitutional structure of the Republic, as it is a realistic example that one has spent time in jail while awaiting trial, and the reality in terms of Section 12 of the Constitution, as you can see here for yourself, imposes an obligation that everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause, not to be detained without trial. You see, the reality that one has went through is that the Constitution has been changed, and the Constitution has been changed under the administration of the incumbent 5th President Cyril Ramaphosa. The reality is that when you call the president to court, you call the president to come and uphold, defend, and respect the Constitution as the supreme law of the Republic. You are not calling the president out of disrespect. Violating, threatening, or endangering the existence, independence, or security of the Republic, fellow South Africans, I am the security of the Republic. I am a Machingilani in the borderline of the Republic. My existence have been violated, my independence threatened or endangered, violated or impaired. Violating, impairing, threatening, or endangering. It's like now the impairment that one is going through, it's you are thinking that Mangolele is not employed in the defense force, or it is and then my reality is that one is employed in the defense force. The treachery achieved by contravening the provisions of Section 4 of the Prevention of Combating and Torture of Persons Act of 13 of 2013, and the defendants are guilty of an offense of torture as persons who commit torture, attempt to commit torture, or incites, instigates, commands, or procures any person to commit torture against the plaintiff, his children Nyeko Mangolele and Aluta Songelwa, his entire family and country and its people. Furthermore, persons under the employ of the defendants participate in torture or conspire with public officials to aid or procure the commission of or to commit torture, and intentionally inflicting severe pain or suffering to the plaintiff, whether physical or mental, for such purposes as to punish him for an act committed by the defendants, or intimidate or coerce the plaintiff to do or to refrain from doing anything, and subjecting the plaintiff into slavery, treatment, or punishment that is cruel, inhumane, or degrading. What is humbly requested to happen in this matter is that the legislature must fulfill the obligations imposed in terms of the object of the Public Finance Management Act 1 of 1999 and secure transparency, accountability, and sound management of the revenue, expenditure, assets, and liabilities of the plaintiff. The legislature must give effect to the Republic's obligation in terms of the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment committed by the defendants, and provide for the offense of torture of the plaintiff and other offenses associated with the torture of the plaintiff, and prevent and combat the torture of the plaintiff within or across the borders of the Republic, and provide for matters connected therewith. Consistency is king. The legislature must, let's do this. Okay, fine. The legislature must, in terms of Section 2 of the Prevention of Combating and Torture of Persons Act, give effect to the Republic's obligation concerning torture in terms of the Convention. In particular, the recognition that the equal and inalienable rights of all persons are the foundation of freedom, dignity, justice, and peace in the world. The promotion of universal respect for human rights and the protection of human dignity, that no one shall be subjected to acts of torture, provide for the prosecution of persons who commit offense referred to in this act and for appropriate penalties, provide for measures aimed at the prevention and combating of torture, and provide for the training of persons who may be involved in the custody, interrogation, or treatment of a person subjected to any form of arrest, detention, or imprisonment in the prohibition and combating of torture. When interpreting this act, the court or independent and impartial tribunal or forum such as the legislature must promote the values of Chapter 2 of the Constitution and the achievement of the above objects. Required proof. All parties are directed to bring all documentation in their respective records in relation to the plaintiff, having regard of the obligation imposed in terms of Section 32 of the Constitution, that the plaintiff or everyone has the right to access to any information held by the state, which is the first defendant, and any information that is held by other persons and that is required for the exercise or protection of any rights. Any information that is held by another person, and that is required for the exercise or protection of any rights. If you are holding information that is stopping payment of my salary, please come out and bring that particular information, because all of us are working for the state, are working for the president, and the speaker is accountable to us, and the judicial authority is vested upon these particular people. National legislation must be enacted to give effect to this right, and may provide for reasonable measures to alleviate the administrative and financial burden on the state. Stated in Cape Town, and that. So here we have this administrative issue that must be fixed. Let's not, for the sake of peace, and cut this one too. It is 18 pages, and then I trust that everything is done in accordance with this particular matter. So this is done, and then with it being done, I will forward the video link on the email that I will send in relation to this matter, and then leave it there for the people in Parliament to consider. Other than that, you now understand the reality that Parliament has to consider, and then you now know what is expected of Parliament, and then you now can see, with me having to explain this particular matter, it will take less than an hour for Parliament to actually read and understand the terms that are here, because those particular people are paid to read thousands of documents per year. Judges, for example, if my memory serves me correctly, is like more than 30,000. But that is the minimum that they must read per year, 30,000 pages. You get what I'm saying? So, and they actually, the reality is that they read far much more than that. So, fellow South Africans, understand that I am true to my cause. I am true to all of you. I do this with honor, dignity, courage, and integrity. I am obligated by my oath to act in accordance with the Constitution and the law, and have acted in accordance with the Constitution and the law, as you have come to see or witness in this particular video. And then in that particular regard, I ask all of you to teach your children to live and enjoy freedom in the universe, our home. Nkosi sikelela iAfrika maluphakanyiswe uphondo lwayo does not need to change its terms. The only term in the national anthem that must change, it is the last part, which is the highest note of the national anthem. And I am one father who refuses to allow my children to scream out to God and say, let us live and strive for freedom. No. My children will say and scream out loud to God in the very same tune, in the very same note, and say, let us live and enjoy freedom in the universe, our home. So it is that particular reality that one is requesting Parliament to consider and then give effect to in terms of the national anthem. Fellow South Africans, without any further ado, I thank you.